Hello, my name is Terry O'Loughlin, and I want to thank you for joining me in this presentation on technology and risk, faraway car deals at the NIADA 2020 convention. Today, we're going to explore technology and risk and faraway car deals. Let me tell you a little bit about myself. I have been an attorney for almost 40 years, and for 29 of those years, I have spent in the car business. 16 of those years I spent with the Florida Attorney General's office, where I investigated and prosecuted car dealers. And for the past 14, however, I have spent time working with Reynolds and Reynolds, protecting dealer interests. As I like to say, I've gone from the dark side into the light. So many of the issues we're going to discuss are born in the legal profession. And I always like to begin with a little joke about lawyers, because they're responsible for many of the issues we'll be discussing today. The question is, how many lawyers does it take to plaster a wall? And the answer is, it depends how hard you throw them. So with that said, we shall proceed. First of all, the fine print. Nothing in fine print is ever good news, according to Andy Rooney. And this is an example of something you can't read. And it's also an example of something that can't be enforced. This is called procedural unconscionability. One has to provide language in print large enough to read in order to be effective. And here's a real disclaimer. I'm going to tell you everything that's true about the law to the best of my abilities, but you're going to have to seek your own legal advice to confirm what I say. Please consider that as you examine these issues. Now, I like this quote very much by Voltaire: judge a man by his questions rather than by his answers. Why is that? Well, because state law applies extensively to this discussion we're going to have, and it varies from state to state. So there are some general rules, but there are a number of rules that are not general. So you have to look at your own state law. So here's the agenda, and I always like to say, put things in perspective. This is like a jigsaw puzzle, a lot of little pieces, because we're going to be going through total 61 slides very quickly. But here's the agenda: the faraway car deals, remote car selling, inherent risk of technology in an ink on paper world, technological remedies, technology and the law, laws and regulations for faraway transactions, and recommendations. So let's begin with the inherent risk of technology in an ink on paper world. In 1940, things were different. Salesmen always wore suits and ties, and in order to buy a car, someone had to make an appointment to see a salesman at the dealership. And 80 years ago, in 1940 as well, all you needed was one piece of paper to buy and finance a car, just one piece of paper. Today, it's 39 feet or more, much different environment. So when you think about it, has the law kept pace with innovations in the marketplace? Laws are pretty slow to react to innovation. But in reality, it's probably not a bad idea that these delays exist, because too much regulation can stifle innovation. And I use the example that in modified crops in Europe, there's a lot of regulation regarding them. Here in the United States, not nearly as much. And so we've made faster progress with modifying crops. Now, are these laws still relevant? The answer is yes. Just because there's no innovation in technology doesn't mean old laws don't apply. And in the current environment, government agencies are much more prone to act in times of hardship, such as hurricanes, economic recessions, and the current COVID pandemic. So, technological remedies. You think about it, with websites, web pages, which are landing pages of desired vehicles, social media, web bots or web robots, social media, web search applications, and virtual test drives. There are a number of these remedies and innovations for selling cars. Kiosks, virtual trade evaluations, cell phone applications, virtual conferencing, machine learning, self-discovery methodologies, virtual agent coaches, centralized F&O offices where there's only one office, and there might be multiple stores, but they'll report to the one store for the final transaction and closing. And then you think about the other technological remedies, the signing ceremony itself, where all the documents are signed when the vehicle is finally, the transaction is finally brought to a conclusion. The electronic document access, the electronic document population, and the document delivery all can be done electronically. And you also have the title and registration and all the DMS functions, all done through the technological innovations. Now, countering that, however, you have the CFPB, the FTC, and state attorney generals and the complaints, and they've increased. These complaints have increased. Complaints are the primary basis for regulatory investigation, prosecution, and reform. Newly adopted technologies will be examined for prosecution. And fraud against dealers and financial sources has increased. So technology might be beneficial in many respects, but also has inherent with it some legal challenges and potential for fraud against dealers. Origin complaints, generally it's 50% or more, are based upon consumer complaints. And by the way, when I say origin complaints, these are actions taken by regulatory agencies. And 20% of complaints, problems arise from advertisers. So between 50, if you add those together, 70% of all problems are in the control of dealers if they redress consumer complaints in advertising. And consumer complaints, they are like ransom notes. If a dealer gets a complaint, he must rectify it because they are radioactive. Technology and the law, laws and regulations for faraway transactions. Let's start with the Uniform Unfair and Deceptive Acts and Practices. This law literally replaced the traditional viewpoint of caveat emptor, let the buyer beware. And so UDAP literally places the burden upon the merchant or dealer right from the start, as opposed to a more equilateral relationship between customer and merchant. And here's the general rule. Does the practice have the tendency or capacity to mislead a consumer? So whatever you do, if it has that tendency or capacity to mislead a consumer, it could be a violation of the law. Let's begin with some of the laws that dealers may contend with that are remote. OFAC, Office of Foreign Asset Control, a very old law, by the way, goes way back to the War of 1812. That's the origin of it. It probably can be handled pretty well remotely, provided the dealer understands who the person is with whom he's dealing. And this applies, of course, to the credit application as well. How do dealers contend with credit applications by someone whom they don't physically see? Very good question. What are the customer identification methods? What are the red flags? And we'll get to that in a minute. Confirmation that the driver's license picture on the license matches the customer's physical appearance. How does a dealership do that? How should dealers address telephone credit applications? I mean, dealers need to ensure their process meets all the disclosure requirements for taking applications, and they are clear to pull a credit bureau report. Then the red flags rule. This law requires dealers and others to take steps to prevent identity theft. That's the whole point, identity theft. And red flag, what is a red flag? It's a pattern, practice, specific activity indicates the possible existence of identity theft. So I mentioned earlier about the frauds going on against dealers. They are pretty much based upon identity theft. Red flags, authenticate the identity of the applicants, customers, and monitor existing accounts for identity theft. That's part of your mantra as a dealer. Dealers should have a red flags program with these features, written identity theft prevention program. You identify the relevant red flags, detect and evaluate red flags at the individual customer level, respond to those red flags, and there are about 27 red flags, by the way, and update the program, and you have an appropriate administration of the program. So for remote transactions in particular, dealers should be asking the customer some out-of-the-wallet questions, conducting an online or video review of the confirming documents and identity, or matching the customer-provided documents and identity against the database. So you need to confirm verbally and through documents that the person is who the person says he is seeking to buy a vehicle. And there are various documents out there that help you walk through this process. And they really should be part of your protocol and included in your deal jackets. Vendor liability. I mean, this is use of third parties for customer contacts and delivery and other purposes. To what degree are dealers liable for the actions of third parties and their employees, which is termed respondeat superior? Answer: high degree of responsibility and liability. The people you hire, the people you contract with, who represent you, you may have to bear the burden of the liability should those parties fail representing you. All right, the Home Solicitation Sales Act. This is state law. Does the state permit offsite dealer premises sales? Good question. Are there additional sale disclosures required? Another good question. Is door-to-door soliciting legal? The answer is yes. Supreme Court has ruled that traveling salesmen have a constitutional right to go door-to-door, and state and local governments cannot pass laws prohibiting that exercise of the First Amendment rights. Solicitation Sales Act. These are sales solicited by a seller and entered into by a buyer at a place other than the seller's place of business, commonly known as a door-to-door sale. So that doesn't restrict it just to a home generally. The main thrust of home solicitation sale law is a buyer's right to cancel a contract within a specified period of time in accordance with prescribed method. So that's important to note that if it's a home solicitation sale, there might be a right for the buyer to cancel the contract. Where do you find these solicitation sale provisions? They can be part of the Retail Installment Sales Act law or the UDAP law. All laws require personal solicitation in the buyer's agreement or offer to purchase must occur at a buyer's residence. And this relates to the Federal Trade Commission Cooling Off Rule. It's officially called the Federal Trade Commission's Rule concerning cooling off period for sales made at homes or at certain other locations. The FTC rule requires a cooling off period for door-to-door sales. And the rule requires written oral disclosures, gives a buyer a 3-day right to cancel misrepresentations regarding that right, restricts the seller's ability to assign the contract for a period of time. So a sale, lease, or rental of consumer goods, such as a car, in which the seller or his representative personally solicits a sale, including those in response to or following an invitation by the buyer, and the buyer's agreement or offer to purchase is made at a place other than the place of business of the seller. For example, buyer's residence or a facility is rented on a temporary short-term basis, such as a hotel room, a convention center, fairground, restaurants, sales at the buyer's workplace or in dormitory lounges. So I referenced earlier the home solicitation sales. The FTC broadens that somewhat regarding the location of that sale. Now, the term personally solicits is not defined. The term place of business, however, it's defined as the main or permanent branch, office, or local address of a seller, such as the dealership or store where your cars are sold. Now, the cooling off rule doesn't include certain transactions. And this first bullet point, made pursuant to prior negotiations in the course of a visit by a buyer to a retail business established having a fixed permanent location where the goods are exhibited or the services are offered for sale on a continuing basis. Secondly, in which the buyers initiated the contact and the goods or services are needed to meet a bona fide immediate personal emergency. So there's an emergency exception. The third one, it's conducted and consummated entirely by mail or telephone without any other contact between the buyer and the seller prior to delivery of the vehicle. So there are some of the exceptions to the rule. The rule requires the seller, that's you, to provide buyers with a copy of any contract pertaining to door-to-door sale at the time of an execution. So you would need to provide that actual document when the transaction is consummated. The contract must be in the same language that principally used in the oral presentation. Secondly, the contract must contain, in immediate proximity to the space reserved for the buyer's signature, a statement in a 10-point bold font informing the buyer he has a right prior to the midnight of the third business day after the date of the transaction to cancel. So this is where the cooling off process comes about. This period of time the consumer can decide to reverse his decision. The rules require sellers to furnish each buyer the completed form in duplicate, captioned either notice of right to cancel or notice of cancellation. And the rule requires sellers to inform each buyer orally about this right to cancel. So it has to be done in the form of a written document and in an oral manner. The FTC Cooling Off Rule prohibits sellers from negotiating, transferring, selling, or signing any note. The retail contract rule, hanging the paper prior to midnight of the business day following the date of sign or the goods or service are purchased. So there's also a period of time that you can't immediately go out and sign the contract. And the FTC, they can seek penalties of up to $43,000 per violation. It can be very expensive to violate this rule. And once again, note the various state laws impose their own laws that do not necessarily mirror the federal laws, so dealers need to check their state's law too. So the Home Solicitation Sales Act relates to this. It's not exactly the same, so you need to go back and forth between the two. Now let's think further about the FTC Cooling Off Rule. All aspects of the transaction, the trade-in allowance, the sales price, and voluntary protection product should be fully negotiated before this vehicle is delivered. Now, everything should be done prior to delivery. Test drives must be relegated to just the test drive. Any personal solicitation or negotiation during a test drive with the customer could trigger the rule. And the third bullet point there, the delivery of the purchased vehicle should only include the ministerial act of obtaining signatures on the final transactional documents. Only if required by state law should the salesman ever deliver the vehicle. Because the rule could be triggered should the salesman's presentation border on what appear to be further negotiations. All right, let's look at specific off-site sales issues. Some other ones. Home deliveries. If delivery of the vehicle to the buyer is considered an action required to complete the sale of the vehicle, in some states may require delivery of the vehicle occur only at the dealer's licensed established place of business. So that's an important point. So in those states, dealers may not be permitted to deliver the vehicle to the customer's home. So the dealers may be required to deliver the vehicle to the customer at the dealership. So dealers, you could recommend to the consumer that the customer, the contract with the shipping company to pick up the vehicle from the dealership. If dealers are permitted to deliver the vehicle to the customer's home, once again, the dealer should only do so. It should only be the ministerial act of obtaining signatures on the transactional documents. So you don't want it to become further negotiation to trigger some of those other laws that then require disclosure and cooling off and so forth. Example of off-site sales prohibitions. In Texas, a dealer may sell or offer to sell a motor vehicle only from an established and permanent place of business approved by the state, meaning the dealership. How about extraterritoriality? That's when you retail vehicles across state lines and mandated boundaries. One would have to consider putting language in the agreements, the contract, as to what law applies, what jurisdiction applies. And there are some other laws in each state as to does the consumer, when the signature is made, does that control the application of the law of the jurisdiction of that state? And so, as I said earlier, the state law is so important here. If you're selling vehicles in an extraterritorial manner, one would want to know those issues before engaging in those types of sales activities. DMV regulations, possession of certificate of title, time and requirements. Some states require dealers have actual physical possession of the title before dealers offer vehicle for sale. Indiana and Texas, for example. The second bullet point here, some states have deadlines for dealers to file the registration and or title application for the customer. Contractors and finance sources are likely to make dealers responsible for a delay. So the actual registration and title procedures and protocols have to be observed because they could trigger some problems. Any delays in processing a title application, and includes a request to have the finance source's security interest noted on the title, could result in the security interest being set aside in a bankruptcy. Obviously, that's a concern in certain cases. And exercising your relationship with the state's electronic titling system with a dealer and the finance source certainly should be utilized. All right, Sunday blue laws. There are 28 states with blue laws, and they vary by state. Different counties have them. And the whole concept of blue laws came about. Why they're called blue laws is that up in New England, I think it was New Hampshire or Connecticut, one of those states, when they were initially issued, it was issued on blue papers. That's where the term blue law comes from. And Sunday blue laws, Illinois, Indiana, or Illinois, Iowa, Maryland, Pennsylvania, Texas, number of states, 28 states. Some states, no vehicle sales are off-premise sales. In other states, you can't even advertise. So it's important to be aware of that because it impacts remote sales activities. Insurance issues and risks. Insurance covers delivery and accidents. The concept of tort law addresses physical accidents. Who is liable? And damage the vehicle en route to customer's residence. Once again, that liability, generally it applies to dealers, but it's something you'd want to know about, something you'd want to insure against. Other considerations: advertising, how do state advertising laws affect home solicitation and delivery? Initial and ongoing contact. This is really important. Telephone, fax, email, canned spam, and text permission. Before and after transaction, you'd want to have some kind of language about controlling that. There's a lot of litigation here. And you'd also want to look at the next bullet point, transmitting non-personal public information without encryption. That's quite risk-laden to do so. And other related issues, the Telephone Consumer Protection Act, the TCPA, a lot of litigation there. You'd want to understand that to some degree. And the Magnuson-Moss warranty disclosure and pre-sale availability. How does that interact with all this? And also the Service Member Civil Relief Act, SCRA issues. You want to be aware of those as well if you ever deal with the military in possible remote sales. Other considerations: marketing, online sales presentations. How are you handling them? The maintenance of those presentations. The internet solicitations, how are they working? How are they being executed? Face-to-face online. For a Zoom presentation, for example, dealers initially disclose that the customer remains hidden. Is that something you'd want to not allow for identification purposes? What is legally triggered, necessitating other disclosure when it comes to marketing in the faraway, distant transaction? How about payments by cash, check, or credit card? Transmitting down payments. How is that being handled? Once again, the potential for risk, potential for liability, potential for money being diverted. Spot delivery and right to cancel. How are they handled remotely? And foreign language issues, we've touched briefly upon those. Other considerations: how about rewritten contracts? What's your return policy? Franchise law issues. They relate to this at all? Are there manufacturer-dealer issues in franchise contracts? Are there financing source dealer issues in dealer contracts? Dealer agreement language. Many form dealer agreements have representation of warranty, and that's a term of art. Rep and warranty, representation of warranty by the dealer. The entire transaction, including the delivery of the vehicle and the buyer's acceptance of the vehicle, occurred at the dealer's licensed place of business. So even if the state law doesn't mandate that the vehicle be delivered at the place of business, could the agreement that a dealer has with the financing source have language in it that requires that particular approach to selling cars? The odometer reading is an interesting one. Does the exact odometer reading of the vehicle correspond with the documents? If you sell a vehicle remotely and the vehicle retail contract says the vehicle has X number of miles on it, it's on the contract, and you drive it, and you add another 20 miles, let's say, how does that change? Well, it's not exact. So do you need to ship the vehicle by a truck? Private and safeguards issues and local zoning, other issues that might need to be considered. All right, moving along, laws found in dealer documents. You got traditional and new age, what I like to call new age documentation. UETA and ESIGN, most forms can be signed electronically, except for certain DMV documents still may require ink signatures. Customers entering into retail installment sale contracts have an opportunity to review the contract in a form they can keep prior to execution. So regardless of whether or not you execute the documents electronically, the consumer has a right to review the contract in a form they can keep prior to execution. You want to study that language and how that should be executed. There are a whole slew of laws regarding this. We'll go through those. All forms of document law that apply. The 39 feet of document I mentioned, there's a plethora of law that is in each of those documents that needs to be observed and followed. New Age Electronic Law, UETA and ESIGN, UETA, Uniform Electronic Transactions Act, that's state law. ESIGN is federal law. And they both grant legal recognition to electronic signatures of records if all parties choose to use electronic documents. So in other words, consumers have to opt in to utilizing electronic documents, the electronic procedures. UETA, ESIGN, they're similar. They provide that electronic contracts and writings are equivalent to traditional ones, and they authorize replacing writings with electronic records, and they authorize electronic signatures. And a record, anything that's can be inscribed on a tangible medium, the stored electronic medium, it is retrievable in a perceivable form, that suffices. Electronic record, a record created, generated, sent, communicated, received, or stored by electronic means. That makes good sense. Wet signatures, dry signatures. Wet signature, signed by pen, right? Applies the signature has time to dry. Where electronic signature doesn't. It can be a type name, it can be an image, it can be a pin, it can be clicking, agree or disagree, or handwritten but digitally captured signature. Various ways of approaching that. This map shows there are all but 3 states that have passed UETA, Uniform Electronic Transactions Act. These 3 remaining states, however, they have laws similar. The legal requirements compliance change in a digital environment, and if so, how much? Well, if you look for, these are examples. Arizona, that in at least 10-point bold type in capital letters immediately above the signature and adjacent to the signature bold face type, size equal to 10-point bold type. I'm giving all these examples to you that various statutes require language to appear in a certain way. Signatures have to be near certain disclosures. This is true whether it's in an electronic medium or, such as a computer screen, let's say, or in a piece of paper. So this is the ink on paper law that I mentioned earlier. It still applies to the electronic world. Various states mandate signatures and initials must be placed near certain disclosures. Directional language for documents. Directions for location are provided and are dictates of the law. So regardless, once again, it's an electronic form of presenting documents. These laws still must be observed. Here's a Wisconsin example. This consumer signature must be immediately above or adjacent to the place for the consumer signature. So you have a line signature for a line, and you have all these disclosures. They have to all be together. It can't be done on one page of an electronic document and then a following page. So one has to use the electronic medium pretty carefully. Ink on paper laws apply to electronic documents. Many federal and state laws have been written for an ink on paper world. Think about it: type size, font size, emboldened words, italicized words, colored wording, box disclosures, and the term clear and conspicuous. It's a term of art. This language must be recognized and provided to consumers. So, with all of that said, let me make some recommendations that probably some of you can readily figure out. First of all, analyze your dealership remote sales practice. How are you handling remote sales? What is your business model? Then, how do the state laws apply to these practices? What state laws are there and how do they apply? Third, recognize how federal law applies, interacts with state law. Because once again, federal law is not exactly uniform with state law. Fourth, I think it's important when questions arise, you consult with your dealership's legal counsel, make sure you're doing correctly. There's potential liability here, and that's why that's so important. And you should have a written remote sales plan. I think writing down your business plans is helpful, and it will enable you to think about and address some of these serious legal issues. Finally, remain vigilant regarding UDEP, unfair and deceptive acts and practices, because that's the basis for many of these lawsuits and actions taken against dealers. And with that, thank you very much for listening to me, and I hope you have a great convention.